If the tenant doesn't pay the rent and a landlord brings forth an unlawful detainer action, if the tenant explains to the court that that was an improper rent increase, then in that situation, the landlord will lose the case. Also, what can happen is 4 years down the line, a tenant is at a cocktail party and is talking to a landlord attorney or a tenant attorney and mentions how his rent got raised improperly in January of the year 2020. Well, that would then rise to a level that a civil suit could be brought against the landlord.
Hi, this is Kris German from The Apartment Dealer, bringing you another episode of The Apartment Dealer Show. And with me today is Mr. Dennis Block. Dennis has been a real estate attorney now for over 4 decades, and most notably known for being and coordinating 200,000 eviction cases, over 200,000 eviction cases. So Dennis, thank you for being with us today.
And nice to meet you too.
Good to meet you. So I know we just getting familiar with each other. This will be the first time you attend or speak at our apartment owners educational luncheon. It's a pleasure to have you, especially because your forte, your repertoire is eviction cases, and with the new rent control law, I know people are chomping at the bit for us to discuss that, which we will, but obviously people are going to be drugged before the courts if they didn't do certain things concerning the law, and so that's why we look to have you with our audience. But before we go there, if we could start a little bit more granular, some of our viewers may have been lucky enough never to have been involved in an eviction case. So could you walk us through just from point A to point Z, and maybe something more difficult than they didn't pay rent. So let's say I have a tenant who's a nuisance, bothersome to other tenants. What's step A to begin processing the eviction, and how does that end?
Well, for a nuisance case, that really needs to be evaluated by an attorney, whether there's enough cause to evict. Now, obviously, if we're talking about a non-rent controlled area and the tenant is just on a month-to-month tenancy, we would just serve a notice to quit, either a 30 or a 60-day notice. We don't have to prove any nuisance conduct, and that would be an easier way to go forward with an eviction case. But the problem is if you're in a rent control district, or potentially the tenant is on a lease, a fixed term lease, what do you do in that situation? That has to be evaluated by generally an attorney, whether the conduct of the tenant rises to a level of nuisance. Nuisance is described as an unreasonable interference with the comfort, safety, enjoyment of other residents or the owner of the property. Typically, you're going to have somebody who's playing loud music constantly, not just a one-time situation, or they're banging on other people's doors, or throwing garbage or threatening other tenants. And in that situation, assuming it rises to the level of a nuisance, we would serve on that tenant a 3-day notice to quit, giving him 3 days to vacate the premises. Most rental jurisdictions that have rent control would require us to describe the conduct that the tenant is doing, and also to put names of witnesses in that notice. That notice would then be served on the tenant. Typically, the tenant does not vacate at the end of the 3rd-day period, so we would have to file a lawsuit called an unlawful detainer. That is an eviction lawsuit that results at the end of the lawsuit of a sheriff physically escorting that tenant off the property. The process is that once that lawsuit is filed, the tenant is then served with that lawsuit, and the tenant can contest the case. If he doesn't contest the case will move relatively smoothly by way of what they call a default, that he didn't contest the proceedings. If he does contest the proceedings, then we're going to need to request a trial, and we'll actually have to bring witnesses to courts to prove to the satisfaction of the court, the judge, that in fact that his conduct rose to a level of nuisance where it would support a judgment being issued against him for possession.
And as landlords are going through the eviction process, what are some common mistakes you see them make again and again? And had they avoided them, they would have won the case, but they had this blunder, so now they automatically lose.
Well, there's a myriad of things. We call them gotchas. There's probably about 50, 60 on any one particular case. A lot of them deal with procedural mistakes, dealing with, for example, rent control. In Los Angeles, which has had rent control since 1979, you have to have your units registered. So if the tenant hasn't paid you the rent, for example, for 4 months, and you served a 3-day notice to pay rent or quit, and the tenant didn't pay, you bring your case to court. You can easily lose that case because you didn't register your units with rent control, or even if your units were registered, that you didn't, before serving a 3-day notice, serve the registration certificate that you get every year from the city of Los Angeles on your tenant. So that would be a procedural mistake, and there are tons of them that landlords can make, which quite frankly is the reason why most landlords should engage the service of an experienced attorney who can walk you through all these issues. Many times clients will come into our office or call us on the phone to initiate a case, and just a view of their story, I can immediately tell them that we're going to have to start all over again. We're going to have to issue a new notice because procedurally they haven't done the correct thing, even though the tenant hasn't paid the rent and there's no proper excuse for it.
Now, with respect to rent control, it only has been law now a little over a month, passed in October, but now it's been a law, at least in those cities that didn't have rent control prior.
Correct.
I should preface that. So with this new statewide rent control, have they outlined what are the punishments if you don't follow the law as a landlord? In other words, they're saying the rent cap is X. Well, you know what? I exceed that. Or I was supposed to roll back my rents because I raised them too much last year. You know what? I'm not going to. Is there an outline of what the punishment is going to be for landlords who don't follow the guidelines?
There is nothing in the law that states that the state will come down on you, will fine you or penalize you because you didn't comply with the law. There is no, quote, state rent control office that will be knocking on doors or taking tenants' complaints. It's all going to be based on what the tenant does. So, for example, if the current rent raise amount, the percentage is 7.9% for the state of California. If I raised my rent more than that, and for a rent-controlled unit that's under the statewide rent control, and I did it more than the allowable amount, there really is, quote, no punishment by the state. But the tenant, for example, if the tenant doesn't pay the rent and a landlord brings forth an unlawful detainer action, if the tenant explains to the court that that was an improper rent increase, then in that situation, the landlord will lose the case. Also, what can happen is 4 years down the line, a tenant is at a cocktail party and is talking to a landlord attorney or a tenant attorney and mentions how his rent got raised improperly in January of the year 2020. Well, that would then rise to a level that a civil suit could be brought against the landlord to disgorge all the additional rent taken and actually even sue for additional penalties. So for those landlords out there that think to themselves, well, there is no real rent control board and the tenant's paying me the rent, so what if I'm getting a little bit more money? My suggestion to them is don't do it. Roll back your rent to the proper amount, which is a 7.9% rent increase. And don't go years and years down the line, which could be, in all fairness, a ticking time bomb.
And in your opinion, is there any hope that this new statewide rent control will go away? I know, for example, in the city of Long Beach, they issued a lawsuit against the city of Long Beach. Is there any hope, anything the landlords can do to fight back? It seems like there's no one really rallying the troops, if you will.
Well, I think there's a lot of people rallying the troops. This law is set to be only go for 10 years, but my expectation, it will go until your grandchildren have grandchildren. That's how long. I don't think there's going to be any rollback. We live in a state that supports tenants' rights beyond anything, of course, that is fair. And rent control is here to stay. It's up to the landlord to understand how to get around this new rent control ordinance, how to keep your rents at market level so that you don't get hit with the onerous factors that can be imposed by this statewide rent control.
And my understanding is you're a landlord yourself.
That is correct.
And I own multifamily. So when I'm framing the conversation of multifamily investing, I like to talk about that we're all building a financial legacy. I imagine for you, your rentals will serve as a portion of your retirement at some point, and mine will serve likewise. And then we'll think about what it's going to mean to our heirs. And while we're building this financial legacy, I've coined the idea that there's really three pillars, if you will. And the first pillar is maximization. Maximization meaning, from my side of the table as a realtor, hey, how can I help landlords get rental rates up? What capital improvements can they do to their property so they can raise value, so they can either refinance something like this? From the lawyer's perspective, again, under the idea of maximization, how does someone maximize their chances of winning if they get drugged before the judge, drug into the eviction court? What really enables a landlord to ensure that he comes out the winning end of that?
Again, I think what you need is to have an attorney who's experienced in this area of law, who will guide the landlord through the process so that at the end of the case, the tenant does have to vacate the unit. And of course, once the unit is vacated, then the landlord is allowed to raise the rent to market level. So, for example, I've had clients call me up complaining that their rents are really low, they're under rent control, be it the state or a local rent control jurisdiction. So I'll start to talk to the landlord, and then the landlord will casually mention that the tenant hasn't paid rent for the last 3 months. So, and of course I start to smile, because one of the easiest way to get your rents to market value would be to evict a tenant based on non-payment of rent. And then once the tenant is evicted, to raise the rent to market value. And so there's many opportunities in terms of what the tenants are doing on the property, maybe having extra people there, maybe they've made alterations to the premises, maybe they're parking cars that they shouldn't park. These are all grounds that we use to terminate a rental agreement and to get the rents to market value.
And the next pillar that I move people through is the pillar of growth. So for a realtor, that would be something like a 1031 exchange. Hey, they have a 5-unit. We find out that their equity would be better served than, say, a 10-unit. They're going to have more net income and the like. From an attorney's perspective, as someone's going through that growth pattern, or maybe the other side of that coin, they're avoiding growing because they think that growth means more tenant headaches, and maybe I'll just be happy with my 5-unit that I own, so they stay away from growth. What's some things and being a landlord yourself, they just need to be cognizant of as they grow in the number of units, the number of buildings they own, to keep themselves out of the eviction courts?
Well, I mean, again, you can, if the topic is getting rents to market value, if you wanted to avoid going through an eviction case, there's no way that you can just merely walk up to a tenant and say, you know what, you're in a $1,500 apartment, but truly the value of this apartment is $2,200, and I think it would be fair for you to pay me that. Now, if the tenant agrees to do that, then the landlord still is committed an illegal act. You cannot take more rent than what is legally permissible, notwithstanding the fact that the tenant agrees to pay it. So that's not an avenue that you can use. Truly, the easiest way is to go through an eviction process. But other ways, when you have a tenant who isn't doing anything wrong, he pays his rent on time, he hasn't violated any term of the rental agreement, or is not a nuisance. So there's another avenue that many landlords use, and we call it in our office here a voluntary vacate agreement. A lot of people call it cash for keys. And in that situation, you would walk up to a tenant and offer them money to move. Now, it seems inconceivable to most landlords that why would I pay a tenant? And we've had landlords give up to $50,000, but the typical payout is $20,000. And to most landlords, that seems inconceivable to them that they're going to pay a tenant $20,000 to vacate their own unit. But clearly, on an economic level, a simple math equation, if you're getting $1,000 for a unit, but you could get $2,000, that means that literally in 20 months, you're going to make back your investment. In addition, as a realtor, I'm sure you are aware of dealing with the concept that if buildings are selling based on the income of the property, that you've just raised the value of that building at least $150,000, $160,000 just by taking in an extra $1,000 income per month. So the voluntary vacate is a very popular vehicle that we use to encourage tenants to vacate so that landlords can do a rent increase.
And I have to thank you with regards to this respect because as rent control was passing in October, I saw a live webinar, if you will, that AOA conducted with yourself, and you were walking through the new rent control proposed law. And I was in escrow purchasing a building myself, where, if you believe it or not, tenants on 2 bedrooms were paying $700 because it was being sold by the original builder, and now the woman was in her 80s. So at this point, the law hadn't been passed, but it was discussions. We said, you know what, we need to rechange everything and just give everyone 60-day notices to vacate. So it didn't come to the point of where it is now. You have to do substantial improvement and so forth. But along the way, some people, of course, said, no, we're not going to leave. So we offered them cash for keys, and we were able to vacate the whole property. When someone's doing cash for keys, what are some mistakes that you see them make that then eventually they are dragged in front of the judge because there was a blunder of the agreement itself?
Well, there is no, in statewide rent control, which just passed, there really has been no procedures that they've set up per se. Obviously, you have to have a specific agreement which states when the tenant is supposed to leave, what money is to be paid, when it's to be paid, how are you going to handle the security deposit, and also during this interim period of time when the tenant's still on the property waiting to leave, is the tenant supposed to pay rent? So the landlord needs to go through all these procedures. But when you're dealing with, for example, Los Angeles rent control, if I have, and this is, most people have no idea as to the problems that can occur when you're dealing with a cash for keys. In Los Angeles, if I and a tenant agree that I'll pay him $20,000 to move, and we sign an ironclad agreement that I will vacate, for example, in 2 months, I get the $20,000 up front, and everybody signs it, it's notarized. Now, when that 2 months comes and goes and the tenant doesn't move, most people would think that you could easily bring forth an eviction action to evict that tenant. He agreed to move. He has the money in his pocket. Unfortunately, under the LA rent control ordinance, there are 12 reasons to evict, and that is not one of those reasons, that I signed an agreement to move and I didn't move. So these are the kinds of problems that tenants can get into. Now, that's not to say that that's going to happen all the time. Tenant's going to get the money, they're going to vacate. We use a special agreement that allows us actually to evict the tenant, even though there is no specific ground in Los Angeles, we do it in an indirect way, which allows us to bring forth an eviction action, something that I came up with many years ago to defeat this issue dealing with LA rent control. But there's a myriad of problems. Again, these types of situations, you really need to deal with an attorney who's well-versed in this area of law and has obviously done it for a long time, so to kind of lead you down this path where your path is successful.
Now, many of our viewers are, mom and pop in the sense that, say, they own one 5-unit, one 10-unit, maybe 2 10-units, something like this. And they've owned them for a long time, so they get chummy with the tenants. They start a payment plan for the rent. Some of the rent they take on the 1st, some on the 7th, some on the 15th. They start this program. But then eventually, the hand that feeds them bites them. Something happens, and now they're in a dispute with a tenant. And my argument has always been that it comes down to management style, that it needs to be friendly but businesslike. Would you say that a lot of these simple issues that landlords run into, it's just because it's their management style and how their relationship with the tenants?
Absolutely. I think that landlords, income property owners have to understand that they're running a business first. And while you can be cordial with your tenants, you can be nice to your tenants, but it still is a business relationship. And I'll see many landlords that will allow rents to go on month after month after month because they're either intimidated about bringing forth an eviction, or more specifically, they're really not running it like a business. If you are in the business of managing income property, then understand that that's what you are. You're a business person. If you cannot act like a business person, then what you really need to do is you need to sell your buildings and get out of that business. As nice as a market like, for example, Ralph's is, you're not going to walk in there and ask for a steak and they're going to give it to you. They're going to charge you for that. And the same thing is true of landlords. Landlords are no different than any other person. Now, anybody in business needs to be nice to their clientele. That's obvious. And the same thing is true for landlords. Landlords need to do their part as well. If something is broken, it's good business to fix it. It's good business to fix it because you want your tenants happy. You want your tenants to pay the rent. And a landlord is not different than any other person. Unfortunately, the media makes all landlords out of slumlords. Nothing could be further from the truth. The truth is that many more tenants create the problems than by a far percentage than the small percentage of landlords that create problems. But in any event, landlords need to run a good business, and by running a good business, they can maximize their profits.
Now, at our educational luncheon, a portion of the event is dedicated to your questions particular to your situation that you would want to put forth to, say, Dennis Block or Steven Spear, who's also the real estate attorney, or any of the number of speakers we'll have with us. So to give you a flavor of that, Dennis, I want to just ask you a couple rapid fire questions here, because again, it's going to be an open forum to take all your questions. It's like having a free consultation, if you will. Not free, I mean, it's at my expense, but a free consultation with Dennis to help you and assist you. So, late fee. Is there parameters for how much a late fee can be when they don't pay the rent on time?
There's specific parameters. Most late fee provisions in rental agreements are illegal based on a case that came down a few years ago, a California case. You have to have specific language in your rental agreement that gets it away from just being a penalty. So if the typical language is, if you don't pay your rent within 5 days, there's a 6% late charge. That is illegal in the state of California. For anybody who wants to know what the proper language is, it is in my website. If you go to evict123.com, EVICT123.com, go to the free form sections and look at my lease, and you can copy that language, which has specific paragraph of the specific language that you need. I put it down where we're charging on a daily rate, like $3 a day, up to $20, up to 20 days. And with that language, it makes it a legal late charge. But one thing is certain, you cannot ask for a late charge in a notice to pay rent or quit. That's a common mistake by landlords. You put a late charge in a notice, your case will be thrown out of court.
Wow. Next question. You find someone living in your unit that's not on the lease. Is that automatic grounds to evict? How do you get that tenant out?
If you have a rental agreement which limits the amount of occupants, that is certainly a ground to evict. We do that case all the time. There's a notice called a notice to perform or quit, which is also on my website, where you would fill that out saying that pursuant to the terms of the rental agreement, only Mr. A and Miss B can live there. You have brought an additional person. You don't have to name them, but you've brought an additional person, and within 3 days, that person has to vacate. If the person doesn't vacate within the 3-day period, then the landlord has the right to bring forth an unlawful detainer action to evict everyone from the unit, not just the additional person. So that is a kind of a popular way that we use to evict tenants. Or, even if you're not talking about raising rents, landlords should be controlling who's living in their units. They went through the application process. When they leased out the unit, they went through a credit check. They want to know who's living there. If this tenant decides to bring in an additional person, that truly is a violation of the lease and does give cause to evict.
And at our event, of course, we're going to walk through the rent control law, or I should say Dennis and Steve, our two real estate attorneys, will walk through rent control from A to Z so you have a full understanding. But obviously, that's not the only thing plaguing landlords in terms of the eviction courts. But for those attendee or those landlords who are maybe thinking, well, I'll just stay home, or maybe it's going to be one of these things where there's a big pitch. Based upon what you intend to share at the event, if I'm a landlord, why should I be in attendance?
Well, the topic, of course, is dealing with statewide rent control. First, you're going to hear me talk about the concept of rent control, which I like to really call it tenant welfare, because quite frankly, that's what it is. So I'm going to go through the parameters of what this is all about and how unfair it is. But more specifically, I'm going to tell you what you need to know about the statute, whether the statute affects you, what rights you get from that statute in terms of rent increases. But I'm also going to go through a very simple procedure which is going to allow you to get around statewide rent control, where you'll be able to evict your tenants and raise your rents to market value. I think this is going to be an invaluable discussion and seminar that we're going to be putting forth here. And it's really going to give landlords a true step up to obtain market value for their property.
Dennis, thank you for your time.
Thank you, sir.
If you're watching this video, that means there's only days left to RSVP for the event. I implore you, there's no charge, there's no strings attached, there's no ulterior motive other than to empower you, the landlords. Again, this is Kris from the Apartment Dealer, wishing you positive cash flow, tenants who behave, and much protection from Uncle Sam. Thank you.